panel de expertos quienes estarán presentando diferentes aproximaciones a la relación entre la regulación ex ante y la intervención ex post en los mercados digitales. Good morning, everyone. Especially to our panel of experts who will be presenting different approaches to the relationship between ex ante regulation and ex post intervention in digital marketing. Today is the first event of the Pontificia Universidad Javeriana Research Initiative on Digital Competition and Electronic Commerce. Our goal is to promote research and discussion on e-commerce and its relationship with competition law and regulation, through interaction among students, academics, lawyers, economists, public authorities, legislators, regulators, businessmen, associations, and the general public. Now I'm going to switch to Spanish in order to make a brief introduction to the topic. But first, I want to thank the President of the Colombian Association of Competition Law and the Director of the Center of the Study of Competition, first, the Dr. Felipe Serrano and Alfonso Miranda. I'm going to switch to Spanish to say some points about it. Hoy la iniciativa o lo que busca nuestra iniciativa de investigación en competencia digital y comercio electrónico es empezar a reunir una discusión que en el país, y no solo señalaría en Colombia, sino que cada vez hay la necesidad de interactuar en este tipo de mercados con las tendencias globales. ¿Qué es lo que está pasando? Tener una política de competencia en mercados digitales que esté por fuera de las discusiones globales nos aleja del horizonte que hoy existe en el mercado. Creo que lo vivimos en política de datos. Hay muchas cosas que hacen muy complejo tener las compañías dialogando con el conjunto de obligaciones que hay y la posibilidad de hacer políticas un poco macro que permitan cubrir esas necesidades, sino que todo este conjunto de disparidad de regulaciones y de herramientas específicas que deben estar cumpliendo las compañías, se hace muy difícil que la misma norma tenga la efectividad que se busca. Y no por el deseo de no cumplir con las normatividades, sino por las disparidades que hay en la forma regular, porque pues cada quien tiene una forma que ve plausible, que considera importante para poder aportar y controlar y proteger los datos, cuestión que es de la mayor importancia, pero que al final del día genera esas disparidades y esa dificultad en el cumplimiento. Lo mismo parece ser la tendencia o el camino que se sigue en los mercados digitales. Y lo estamos viendo, unas intervenciones, unas primeras regulaciones, proyectos regulatorios de cara a la Unión Europea y Estados Unidos marcando como unas directrices sobre cómo controlar a los gatekeepers, cómo mantener a un conjunto de empresas como en políticas de cumplimiento de mercado, y que al final pues se requiere tener muy claro si efectivamente hay un desbalance frente a la innovación, frente a las cargas, si el remedio puede resultar un poco más costoso que la enfermedad. Y lo digo por situaciones particulares, es decir, por ejemplo, para el caso de los Estados Unidos, una de las iniciativas pues va, por ejemplo, en establecer una política muy clara en materia de negativas a contratar. Esa parte de negativas a contratar resulta interesante porque los jueces han llevado la doctrina pues casi a las antípodas, es decir, en el lugar más difícil de ser aplicadas. Esa doctrina de las negativas a contratar o Essential Facilities Doctrine o Refusal to Deal ha sido puesta en ese extremo, donde es difícil aplicar. Entonces, parece ser que la intervención desde estos puntos pues, es recuperar un poco la lógica económica que hay detrás, las posibilidades de no cerrar mercados y además la capacidad que pueden tener también las autoridades de tener en cuenta pues unas doctrinas que permitan el acceso, que disminuyan las actividades de foreclosure o cierre de mercado y que tiene pues ciertas disparidades en la forma de interpretarse. Si son vistos desde relaciones verticales, me refiero por ejemplo, vinculación de productos, si son vistas en cierta forma de discriminación, tienen una forma de ser aplicados, pero si son entendidas para el caso de los Estados Unidos como conductas unilaterales negativas a contratar, resulta que no se aplica la doctrina. Ese punto de la lógica económica que no termina de asentarse y que la legislación tiene una potencialidad de mejorar. Pero está la otra parte donde esa autopreferencia que pueden tener los agentes en los mercados, lo que empieza a generar como cierto, por lo menos la necesidad de ser evaluado. Porque si un agente que tiene una plataforma le da alguna preferencia, por ejemplo, a su nueva aplicación, etcétera, se va a ser considerado ilegal, pues al final del día también es muy complicado decir, es que cómo se califica aquí una aplicación es mejor que otra, cómo decirlo, cuáles son las características para establecer el ranking, o sea que la mía que entra tendría que entrar al último punto y nadie la conozca si puede ser una buena aplicación, es decir, ¿cómo medirlo? Eso que nos lleva un poco pues al caso de Google en la Unión Europea con Google Shopping. Son ese conjunto como ya primeros casos, la necesidad o la visión que tiene la Unión Europea de controlar este tipo de compañías con unas intervenciones muy fuertes y al mismo tiempo una corriente en los Estados Unidos que nos dice una forma de revisar los mercados distinta atendiendo a consideraciones estructurales. Pero ahora, si uno intenta evaluar qué es esto del derecho de la competencia y cómo ese derecho de la competencia puede ser aplicado, pues tenemos muchas palabras que están sueltas: bienestar del consumidor, eficiencia, libre participación de las empresas en el mercado, tenemos una visión también de el proceso competitivo, etcétera. Pero, ¿cómo se mide? ¿Alguien nos dice eso? ¿Cómo se mide? No, no es fácil. Al final del día termina estando en unas consideraciones económicas de si se puede disminuir la oferta, cuál es la potencialidad para que se disminuya la oferta, cuál es el incremento en los precios, cuáles son esas condiciones que van a permitir que los mercados efectivamente cambien. Los demás parece muy complicado de entenderlos y están más como a la argumentación jurídica y se ven los casos que a identificar cuál es el problema real. Y ese conjunto de intervenciones al final del día no sabemos si están mejorando la competencia o por el contrario estarán generando una transferencia de rentas. Y lo digo para el caso donde solo se aplica en materia administrativa, pues que no se compensa o la prioridad es la sanción administrativa, lo que es una transferencia de rentas de la gente del mercado a la administración, pero no sabemos si el mercado mejoró o no mejoró y esos estudios quedan como por fuera. Entonces, hoy hay muchos elementos que llaman la atención sobre estas relaciones que se dan en mercados digitales, o la academia debe tomar un paso pues activo. Lo que hemos querido es hacer un proyecto que sea inclusivo, que permita a otras universidades participar, y no solo pues participar como son unos invitados, sino que tengan la capacidad de publicar, de hacer los foros, de tener ese campo de discusión, pero que al final pueda estar en un lugar, es decir, que más adelante podamos encontrar las discusiones con independencia, con todas las visiones en un lugar, que podamos seguir cuáles son los artículos que hay en Colombia, qué es lo que se está publicando, que sea fácil hacer ese seguimiento, tanto a los proyectos de ley, a las iniciativas regulatorias. Entonces, el objetivo de este centro es darle esa difusión, traer a todos los interesados a discutir, no con un dominio específico de que la javeriana va a ser, no, es más la idea que todos aquellos que quieran participar tengan una posibilidad de publicar lo que quieren publicar, de presentar lo que quieren presentar, y ahí esté, para que más adelante aquellos que quieran hacer nuevas regulaciones, aquellos que quieran intervenir, pues encuentren como una historia de qué es lo que está pasando, cuáles son los aportes que ha hecho la academia. Entonces, atendiendo a eso, pues quisiera pues como continuar Ya dándole la palabra a nuestros invitados. Entonces, listo. Dear audience, today I have the pleasure to introduce you to Mr. Krisztian Katona, who is the Vice President of Global Competition and Regulatory Policy, Computer and Communications Industry Association, and is going to talk about antitrust and digital markets in the US. Dear Krisztian, thank you for being here today, and the microphone is yours.
Thank you so much. Buenos dias a todos. First, I'd really like to thank the Javeriana University, SEDEC, and ACDC, and all the organizers of today's program for the invitation to participate in this panel discussion today. I previously participated in programs organized at Javeriana, including, I think it was on Colombia's accession to the OECD. I think it was back in 2019, the year before the pandemic. And it's really a great pleasure to participate in a program here again. And albeit virtually and only through the screen this time, I see some of you and would like to greet many antitrust friends in Colombia. But I would also like to congratulate Javeriana, SEDEC, and ACDC for launching this very important research initiative on digital competition and e-commerce issues. And as part of my remarks, I will also touch upon the importance of such academic research projects and really their regional and international significance as well. Now, turning to our topic today, which is ex-ante regulation and ex-post enforcement of competition, as we've also heard in the excellent introductory remarks, there's really so much for us to talk about. And in that regard, as I was tailoring my thoughts, I wanted to highlight that my remarks will cover 5 main areas. First, as you just heard, I will discuss relevant developments in the United States recently in this area. But then, very importantly, I want to talk about the global landscape on ex-ante regulation and ex-post competition enforcement. In this regard, a very important question is, do we see international convergence or divergence in this space? Talking about all of this as kind of like the third part of my remarks, I would then provide some key considerations and principles for ex-ante regulatory regimes that policymakers really should take into account as they're thinking about these proposals. And next, a very important and basic question in this space: are digital markets actually any different from other markets and other industries? And one aspect of it, and very important of it, is how does it actually then relate to mergers and merger enforcement? So I will spend a couple of minutes talking about that as well. But last, I will also discuss what I just call Colombia's special responsibility in this area. And then I think as part of that, I will also touch upon the research initiative project too. So starting with developments in the United States, I think we all can see that competition perhaps has never really been more hotly discussed and debated than these days. And that's true in the United States and I think globally. And really much of this discussion is focused on digital competition issues. There are some recent developments in the US I would discuss in a little bit more detail. And first and foremost, as you've also heard in the introduction, currently there are various proposed bills in the US Congress focusing on digital platforms. Although in their names, these proposals are often called competition bills, or they use the word competition as well, they are in fact what I would actually consider regulation. And these bills really touch upon a number of issues, but a couple of the issues I would highlight in particular is a ban on self-preferencing that we've also heard referred to as part of the introduction, and also importantly, a ban on mergers and acquisitions for companies over a particular size. So many of these current US bills would actually prohibit most forms of self-preferencing by large platforms, which is really where the platform gives more favorable treatment to its own product than to the competing products. For example, this ban on self-preferencing could mean that Google or Apple couldn't list their own apps first in search results on the app stores. Or thinking about another example, Amazon couldn't list its own products before other competing products. And the language in these proposals is really vague, and self-preferencing could potentially apply to just about any actions that treat the platform's own products differently than those of competitors. So under these bills, it really seems that the only clear-cut way for a platform, for a company to avoid legal scrutiny, maybe to actually stop selling its own products. But needless to say, that would require us to sacrifice a lot of competition and innovation. So in a number of these bills, there is a similar ban, as I just mentioned in my initial introduction. There's a similar ban for covered companies of a particular size to actually acquire others, meaning there's a ban on company mergers and acquisitions as well. And it's very important to think about how that affects then the broader economy and innovation and the whole, innovative ecosystem in the market. So going back to the title of our program today, ex ante regulation or ex post enforcement, I wanted to pause for a second here, because I think on ex post antitrust enforcement, as we know, it's not unusual for antitrust cases to be complex and fact intensive. But we don't usually have these investigations unless we have reason to believe that the defendant's conduct might actually pose a serious threat to competition. However, absent specific evidence to that effect, we have little reason to assume a serious threat to competition in cases alleging such activity as self-preferencing. And that's really the same with the review of potentially anti-competitive mergers and acquisitions versus banning them outright. So the point is that this threat of competition must be demonstrated and not merely assumed. And normally, as competition practitioners, we all know that in an exclusion case, we ask the plaintiff to demonstrate two things. First, market power, and second, some indicia of anti-competitive effects. But then my concern is that the current US bills, omit the first of these requirements, market power, in pretty much all cases, and they omit the second one, some indicia of anti-competitive effects in most cases. And specifically, they ask whether a technology company is large, but not whether it has the power to exclude rivals in the specific product market. And the majority of violations codified by these bills don't require plaintiffs to show that anti-competitive effects are likely. Instead, such effects are simply presumed. So as a result, under these bills, whenever a large technology company introduces a new product, it may actually face litigation threats for any perceived special treatment on its product, even if the potential impact on competition is likely negligible. And I think the real concern here is that this really will discourage companies from bringing new products to market. And who and what would be harmed in the end? And obviously it's the public, consumers that would be deprived of new products due to these bills. Innovation itself would be harmed. And competition and the economy as a whole would be harmed as a result as well. Now, a key concept of the US and also the foreign proposals that already mentioned as well is who would be covered under them. And I think the key question is, from a risk management perspective for companies and antitrust counsel alike, is which companies would be then designated as the covered companies in the US, or in Europe under the Digital Markets Act, which companies would be considered gatekeepers, or in Germany under a similar proposal, which companies would be what is considered under German law of paramount significance of competition, and so on. And I think on this, I would add that the potential costs of these proposals are very important to be taken into account. I would add one important study on this, which just came out about a few weeks ago, or about a month ago, which was a new study by the National Economic Research Associates, NERA, in the United States. And this NERA study found that the US antitrust bills currently being discussed would cost the US economy up to $319 billion. So it's over $300 billion over time. And this study really concludes that these costs would ultimately be passed on to consumers. The bills are messaged as just targeting particular technology companies. But the study also reveals that the language that relies on market capitalization means that more companies would be captured in just a few years. And based on the study's findings, about approximately 13 additional companies would be covered in the next 5 to 10 years by some of these bills. And likely it would come to over 100 companies in the US economy by the 2030s. So those are the current proposals and some of these developments in the United States. But as I mentioned in my intro, I want to zoom out, and it's kind of like the second part of my remarks, really talk about like what is happening in other jurisdictions in this area, because I think it's very important to take a comparative approach and perspective on what is happening worldwide on competition and regulation in this space. And I think we really have to look at these developments on the global scales and how interrelated they might be or not. And I'm working on these issues, globally and in a number of jurisdictions. And I also very much look forward to hearing from my fellow panelists about these international experiences, including in Colombia and from Marcus in Brazil and Latin America and in Europe and other jurisdictions. But talking about competition enforcement and international convergence or divergence, I think it's very important to understand why a particular action might be a competition violation in one country, but not in another when the facts are identical. And I think, of course, the facts are rarely identical. If we think about it, different outcomes based on different facts or different market conditions really shouldn't be seen as divergence. But focusing on the main substantive areas of antitrust with a really broad brush, we see a lot of international convergence in merger and cartel enforcement. And much of this was supported by the work of international organizations over the last couple of decades, in particular the OECD and the ICN in the 2000s, with really their important recommended practices and best practice documents in these key areas. So if you look at the international landscape, based on this, practicing antitrust internationally, we really can see that there is generally a strong international agreement on substantive tests and standards, and also processes and investigative tools in merger and cartel enforcement. Now, turning to the unilateral conduct area, however, convergence on abuse of dominance has been less clear. It really shows that there have always been some divergence and some tensions in antitrust enforcement and policy. And why is that? I think on the one hand, obviously there are different laws and rules in different jurisdictions in that regard. But also many of these issues might be more local in the abuse of dominance area. In addition, I think internationally there are very different investigation timetables in this space, which would be much more difficult to think about in a coherent way than, for example, merger review timetables internationally. But the differences in general haven't really been too great, and they have been largely localized. But when it comes to digital antitrust, I think there are some features that throw the international divergence question into greater contrast. First, the companies investigated are often global, whereas agencies are national. And I think this can be a very serious element when there's a political sentiment that we feel these days, of deglobalization and perhaps focusing more on national interests in some countries. Second, and very importantly, many of these concerns relating to technology companies often cited, such as, for example, online harms, have really nothing to do with competition. But most countries, obviously, we are competition attorneys, have competition laws and established competition agencies we practice in this space. Many of these competition agencies over time have been very successful in building a competition culture and competition, focused economy, and they became an important part of the market economy in those jurisdictions. Just to step back, remember that in 1990, only about 3 decades ago, there were only about 20 active antitrust enforcement jurisdictions. Today, there are over 140. So over 100 countries have been added to that list over the last couple of decades. But they can also be victims of their own success. And there's a temptation, perhaps, to use the competition tools when the perceived harm is actually not a competition problem. It might be data privacy, it might be something else. And in many countries, new laws and regulations are being enacted to address these issues. But in others, competition is being used to address these issues. So I just want to add that it seems that we've moved to a world in which I think over the last year or so, we see that the expectation is perhaps changing to a certain degree. And you see many comments that say that competition enforcers are more like now ex-ante regulators that really need to solve every perceived problem even before it arises, instead of actually clarifying the law and setting a standard by saying, here is the line of competition violation and you shouldn't cross it. From that perspective, I'm somewhat concerned that competition agencies are somewhat losing the focus that the job is not to address every single competition issue in the marketplace, which we all know is an impossible task. The task is to try and have a system that is very competitive. And I think the US economy has been very competitive because now for a number of decades, there really has been a good system of ex-post competition enforcement by the agencies. So as part of the third kind of like section of my remarks, following up on all of this, I wanted to kind of like add a few considerations and principles when we think about regulatory proposals, and going back to the title of our program as well. Like, what are those regulatory proposals like, and what kind of key principles and considerations should policymakers take into account as we're thinking about these issues? So starting with the fact that it's widely acknowledged that digital platforms provide consumers and businesses tremendous benefits. Given the dynamic and really innovative nature of digital markets, any new regulation for platforms really needs to take into account wider potential implications for both businesses and consumers. I think it's very important for policymakers to assess whether the benefits of any proposed digital platform regulation would really outweigh its potential negative impact for consumers and the economy. And why is that? It's because an overly burdensome and heavy-handed regulation could really significantly hinder innovation and harm economic growth in a country. But it can also undermine intellectual property rights. So I think in this regard, the key consideration is whether the existing enforcement frameworks, including competition, consumer protection, data privacy, and others, really already provide more proportionate ways to achieve the desired outcomes. And I think this can be particularly important in countries where these different missions and policy areas are enforced and dealt with by the same authority. And Colombia is one, with the SIC, with SIC, being covering all these areas. So I think it's very important to think about it from that perspective as well. But I think it's very important that policymakers review actual evidence and past experience to focus any proposed regulatory framework on types of conduct that have to be demonstrably harmful rather than addressing some theoretical or speculative harm. Because that again would risk overregulation and harm innovation and the economy itself. We should keep in mind that new rules should aim to promote competition, of course, and enable innovation in the marketplace by preventing competitive harm and really unfettered regulatory discretion. And I think the integrity of any new regime really should also be secured by procedural protections and review mechanisms. In particular, I think a court review should be a very important element that we have to see in regulatory proposals, and it should be available for decisions that have legal consequences for affected companies. And finally, we should always remember that competition and regulation, they don't exist in a vacuum. And the rules should be really consistent with other regulatory regimes. So it's very important to kind of like keep that in mind. Also, I think we really should highlight that there must be a caution against relying on international regulatory experiments in this area. As I mentioned, digital reforms are being considered in various jurisdictions, and that includes, Australia, Japan, Germany, the United Kingdom, the European Union, of course, and a number of other jurisdictions right now. However, as of today, only one jurisdiction, Germany, has actually introduced an ex-ante regulatory framework, and that was based on, its most recent 2021, amendment to the German competition law, and the so-called, in particular, the 19A section of the German competition law, based on last year's reform, which deals with companies that have a paramount significance to competition. However, this went into effect last year, and the results of this reform are not really yet available. While it's clearly useful, I think, to understand international proposals, I think a very important concern is that the context to those reforms is often lost. Like, for example, some proposed regulatory reforms are the result of particular political dynamics, and there are emerging concerns about the impact of digital-specific reforms. Also, other international reforms are approaching implementation, and I think it was mentioned before with the Digital Markets Act in the European Union. But then the implementation stage and processes for the implementation will actually introduce further issues and challenges as those reforms take effect. So I think that's the key reason that perhaps instead of rushing to adopt reforms that really reflect at this point international regulatory experiments, I think policymakers really should first allow some time to see how those reforms are working and whether they're actually working or whether they're actually harming consumers and innovation. So when it comes to digital competition regulation, as part of the fourth section of my remarks, the focus is often on unilateral conduct issues. And in addition to unilateral conduct, I think it's very important that when we discuss international developments, I also wanted to spend a couple of minutes focusing on mergers and merger enforcement. And the key question that really has been raised in this space in a number of jurisdictions, including the United States, is whether digital markets are that different. Do antitrust enforcers require different rules to review digital mergers? And this came up as part of the current US exercise to review and update the US merger guidelines, which the FTC and DOJ are currently working on. So regarding the process, the US agencies requested comments from stakeholders just a couple of months ago, and the revised set of draft merger guidelines for review and comment is expected over the summer, over the next few months. And the key question that this US exercise has also raised as part of the agency's request for information is really, the review of mergers in the digital economy, including the question whether separate rules are needed. And I think in that regard, first, it's very important for competition agencies to really periodically review and re-examine the merger review rules, just to make sure that they really reflect current practices, market realities, and economic learning. But I think the merger guidelines have been really flexible and adaptable to today's modern economy and business models, including different industries. They really have been, if you think about it, there have been numerous technological developments over the last several decades. Just think about the level of change and development, including, say, the development of the telephone, or then the computer, then the internet, and so on. And I think the competition agencies really have been able to review and assess mergers in this area, in the technology area, using the same set of rules and principles that have been used for other industries as well. There is just not much new in that regard. Technological change and development keeps happening. Of course, the current rules could perhaps benefit from a refresh in some areas. I think I mentioned that it's very important to regularly review those practices. Maybe in the area of data aggregation related aspects of merger review, there can be additions to the guidelines. But I think it's very important that I don't see a need for different rules for digital mergers. And these tools have worked very well over time. But also looking at developments globally, we see that a number of agencies are looking at whether they have missed any digital mergers that they perhaps did not challenge over the last few years. And for this, a number of agencies are also conducting merger retrospectives in this area. For example, in the United Kingdom, the so-called Lear report did a really detailed ex-post assessment of 5 digital merger transactions. But also, over the last 2 years, the FTC in the US conducted a detailed study, but also Brazil's CAGI that Marcus may touch upon, and also the Israeli Competition Authority recently reviewed several years of non-notifiable transactions by technology companies. And the findings of these studies, based on my review of them, they really don't seem to suggest that there is a systemic problem or concern regarding mergers, be it startup acquisitions or the so-called killer acquisition. And again, I would caution against making changes and fixes to the competition regulatory toolbox without really identifying an actual problem first. So last, and really to close my remarks on ex-ante regulation and ex-post enforcement, I wanted to touch upon a very important topic, which is close to my heart as well. And this is what I would call, Colombia's special responsibility in this area. And there are a couple of important things here I wanted to mention. First, today, Colombia really is one of the countries that, for example, also joining the OECD, it's one of the countries that most joined OECD, one of the most recently, but it's also a role model for other developing antitrust regimes in the Latin American region and beyond. And I really see that working with a number of countries in Latin America, Europe, and the rest of the world. And I think other newer and developing jurisdictions in Latin America and beyond are really closely looking at the example of Colombia and the development of its competition and regulatory regime, the prioritization of enforcement and policy issues, and accomplishing enforcement and policy strategies like the agency uses and the jurisdiction applies. And I think the challenges Colombia faced and the lessons learned to understand how Colombia got to where it is today can be very important for other jurisdictions. Colombia can and does serve as an example for other countries, which makes it even more important to have a good understanding of what is at stake when we talk about digital competition. What is the impact of ex-ante regulation and ex-post enforcement on the broader economy or on the innovation in a country? And I think as part of this thought process, academic projects like this research initiative by Universidad Javeriana, SEDEC, and ACDC are so incredibly important. They really can provide the necessary academic DNA, the necessary learning, especially from a comparative and international perspective. And this is really important as I'm personally, for example, not aware of any digital platform-related publications in Latin America. And this can be extremely valuable for policymakers in Colombia and abroad as they look at these issues and consider different options. So again, congratulations on the launch of this very important research initiative. I very much look forward to seeing the results and success of this project, but also I very much look forward to participating in it to the extent I can be of assistance. Thank you very much.
Thank you for a very interesting talk. For sure, you discussed a lot of issues that we have to research and to talk about it, especially the convergence or not in the treatment of digital monopolization interventions, what is happening with the self-preference prohibitions. And for me, the relationship between regulation and enforcement, this is for us a very interesting topic. For sure, the dynamics of regulation in our country can hinder innovation because it's difficult to have a policy that review constantly the results of the regulation, and maybe the technology, the innovation, for sure is going faster than regulation. Thank you, Krisztian. Right now, now I have the pleasure to introduce you to Mr. Marcos Exposto, partner at PMA Brazil, who will give us a presentation on antitrust and digital markets in Brazil. Dear Marcos, thank you for being here today. Please go ahead.
Thank you, and thanks to the Universidad Javeriana for the opportunity. I think it's a very good initiative on the school's behalf to put this project together and to study in depth the trends of enforcement everywhere and see how that reflects in Colombia. To some extent, the same applies here in Brazil. Brazil has been keeping up with enforcement trends, but I share Krisztian's, I agree completely with Krisztian's observations about how enforcement actions should be replicated in other countries, because there are local characteristics and features of each specific market that require caution in replicating enforcement actions. And much of what I'm about to say highlights how CADE has been handling this and how that could differ from other even more mature jurisdictions. So I prepared some slides that I'm going to be sharing with you. Okay, so I see here that you can all see my screen. Well, this, of course, has been a recent hot topic in Brazil, how digital markets should be treated in a special manner, if at all. And CADE has been very active in this particular debate. So there is a move towards digital that has impacted the Brazilian economy very significantly, and this has been exacerbated to some extent as a result of the pandemic, with significant growth in e-commerce and other digital aspects of the market, regulation of medical treatments, that medical consultations that are done online, so on and so forth. A lot has progressed during the pandemic, much more quickly than it would otherwise have progressed. So this naturally has had some reflection in competition law enforcement, but there's been acknowledged caution from CADE. CADE has been provoked a lot about the need of special rules for digital markets. And as Krisztian well put it, so far we haven't identified any flaws or any problems with the currently existing tools that would require a new set of special tools for digital markets. Traditional antitrust analysis has been working properly, and basically there has been not that much change to how the authorities' work is done. So there has been a lot of discussion about the applicability of merger control notification threshold alternatives. So do the current merger control thresholds cover all the transactions that actually need to be covered by merger control and that need to be reported to the authority? And there has been a lot of discussion about this, and there has been some action from CADE, as Krisztian put it, try to identify potentially unreported transactions. But ultimately, enforcement has followed what we know as common antitrust wisdom, basically new market, same tools. And so far, we haven't identified anything that slipped through the cracks and that should have been analyzed. So CADE has had has put some effort into organizing all of their work in digital markets. And earlier, last year, they released a compilation about enforcement efforts in digital platform markets. We'll be sharing these slides with you. There's a link here to CADE's publication. And basically, this is this compiles all of CADE's enforcement actions, all conduct cases, all merger control cases over the past 10, 15 years in a broad range of sectors. And this is not exclusive to digital markets, but it rather encompasses all cases that involve platforms, and here the word is used very loosely. So whenever there's any activity that involves the mediation between two or more groups of stakeholders, two-sided markets, so on and so forth, to the extent that this is replicated in digital markets to some extent, CADE has included these cases all in this specific compilation. As I said, this addresses enforcement both on merger control and conduct fronts, and this follows a previous compilation that was released in 2020 in the beginning of the pandemic, which is actually a brief summary of enforcement actions taken overseas. So they discussed the Lear report, the Stigler report, several other enforcement actions carried out by foreign authorities, and there's another publication to that extent. The important thing here is there's a very wide coverage. It covers several markets. So social media, ride-sharing apps, this was a big deal in Brazil when Uber entered the Brazilian market, and there was a lot of discussion between taxi drivers associations and the impact that Uber had on the economy. Sporting goods retail, so a local company bought the rights to distribute Nikes products in Brazil, and there was a lot of concern over online retail and how that would impact the market in terms of self-preferencing, food delivery services, social media. So there's been a very wide coverage of all digital markets. And there are some cases that involve purely digital markets, such as cases involving social media, the introduction of WhatsApp Pay in Brazil by Facebook. In other cases, deal with more specifically with the shift towards digital. So cases where you would find, particularly in the retail segment, a shift from brick and mortar to digital retail, how that impacts the economy and how merger control is expected to deal with that reality. So to which extent does the digital economy compete with the traditional economy, so to say? And this, of course, impacts these examples of ride sharing, food delivery, retail, so on and so forth. So the conclusion that we can draw from all of CADE's enforcement actions is that there is no one-size-fits-all, and that the authority has been very cautious to always conduct a case-by-case assessment, and they've been very thorough in this type of case, because ultimately there are a lot of stakeholders involved. There are recent entrants to the market that may feel that they are impacted to some extent, and the authority has been conducting these assessments very carefully, but using the same tools that they have always used, and adapting this reality to acknowledge how players might act in a way that's a bit different in the digital economy. So ultimately, we can conclude that there are no big changes to the rules of the game. So both of these compilations, they have a purely analytical work. So CADE does not draw any conclusions or set any policy goals or suggest any changes to how the work should be done. The documents were prepared basically because there's a lot of debate and a lot of concern about this matter, and they want to make the information more accessible to some extent. So these documents were prepared completely in Portuguese, and they basically organized how this has been handled in Brazil and elsewhere, and basically organize all the information in one specific document. And CADE's officials have been very consistent in conveying a message that they plan to continue reviewing matters carefully and on a case-by-case basis. So, so far, they haven't come up with a specific rule that would apply to digital markets specifically, and that would change significantly how the work is done. So they are carrying on with their analytical work and their work both in conduct investigations and merger cases, using the tools that have always been used in the past. And this goes to Krisztian's point about how the facts of the cases are usually not the same. Even though fact patterns might seem similar, there are always local characteristics that need to be taken into account. And even though CADE has kept up with global enforcement trends and naturally has shown that they are paying attention to the impact that this might have on the digital economy, but actions that have been taken elsewhere, such as specific acts that have been released in Europe and in the US, these have not been replicated automatically. CADE takes this in consideration, but always adapts this to the local reality, and takes into account that players might not be the same. So you have players that are very big and that are treated as big tech elsewhere that are not that big in Brazil. And we have our own big players. So Mercado Livre, for example, is a player that's very big in Latin America. And consequently, the digital retail market in Brazil works a lot differently than it does in the US, in Europe, and in other jurisdictions. So, well, case-by-case assessments are very important to make sure that the decisions are mindful of how the local economy could be different than that of other more mature jurisdictions. So copycatting is often inconsistent with the local reality, and CADE has been very careful about doing that. A good example is the Google Shopping case. So this was an investigation about self-preferencing and how the display of Google Shopping's own results could be prejudicial to other price comparison sites that would appear lower in the search results page whenever a customer would search for any specific product. In Brazil, the case was, they conducted a very thorough assessment, and the case was ultimately dismissed in 2019 because CADE was not able to identify any link between what Google was doing and the actual harm that was claimed by its competitors. So ultimately, even though Google was could be giving a preference to their own search results, this was not directly linked to the harm that was felt by competing price comparison sites. In a very similar case about not the same facts, but a very similar narrative, the European Commission imposed a $2 billion fine on Google. So this goes to the point of showing that even though something might require enforcement action, and here I don't have any opinion on either case, so I'm not saying that the European Commission was wrong and CADE was right or vice versa, but it's just that assuming that both authorities conducted a very thorough assessment of this case, they reached different conclusions based on the specifics of each country's or of each jurisdiction's realities. And this is something that needs to be taken into account. And I think that Colombia shares to some extent the same position as Brazil, as a country that always takes inspiration on what's going on in the world, but this ultimately needs to be adjusted to the local economy's own reality. And again, just to wrap this up, there have been some other initiatives. In recent years, CADE has increased the number of injunctions of interim measures, urgent decisions that are imposed on players, citing concerns over the timing of investigations, especially conduct investigations in Brazil tend to take a while. And in fast-paced segments, CADE's concern is that if they don't take any immediate action at the end of the investigation, whatever remedy they impose might be insufficient to prevent harm. These were, even though they are urgent measures, they were applied in very specific circumstances, and they were granted over careful review. And in some cases, when the parties had the opportunity to explain what was going on, these were reversed in a short amount of time. So there is the global and advertising agencies. Basically, these are rebates that the media channels paid to advertising agencies. And CADE imposed an injunction saying that this could be harmful to the market. WhatsApp Pay, this is a joint venture between Facebook and Cielo, a local credit card company. And this was ultimately reversed once the parties had the opportunity to review. And Gym Pass, which is a gym membership solution that allows customers to use any gyms, and they had an exclusivity arrangement with gyms so that they couldn't have similar services. And CADE imposed an injunction regarding the exclusivity arrangements, but that was very specific and allowed previous exclusivity arrangements not to be interfered with because of the investments that had already been made. So even for urgent measures, CADE has been very thoughtful and careful about imposing these injunctions. About the revision of notification thresholds, as Krisztian anticipated, CADE, early on in the pandemic, CADE made a market inquiry asking several companies about all acquisitions that had been made in the past 10 years, irrespective of whether they were reported to CADE. They received a lot of information about these deals, but there is no indication that any alternative notification thresholds would need to be created or that any sector-specific regulation would need to be put in place. So far, there have been no unreported transactions that were identified. There's no concrete action requiring any transactions to be reported to the authority. And there's no public information about the in-depth analysis of any cases that had not been reported. So, I mean, to the extent that we are aware, this investigation is still ongoing, but there's nothing concrete that has come up from that in terms of changes to the authority's traditional tools. And also something that's not specific to digital markets, but will certainly have an impact, is that CADE recently announced that they have created a division that's specialized in the investigation of unilateral conduct. Previously, the unilateral conduct investigations were handled by industry-specific divisions within CADE that usually take care of merger cases. So you would have divisions that are specialized in financial services, healthcare, customer goods, so on and so forth. And these divisions would also handle unilateral conduct cases that were pertinent to those markets. Now, there's going to be a separate division that will specialize only on unilateral conduct. There, again, this is merely an organizational change, trying to bring more efficiency to this type of investigation, but there's no indication that this will have any impact on how the work is done or on the tools that the authority has to conduct this type of investigation. And also, this has more of an impact on digital markets, but early in the pandemic, CADE conducted a major price gouging investigation, requesting information from several players, including several e-commerce players, about abuse of dominance and how prices were increased as a result of the pandemic. Early on, there was a lot of a significant increase on the price of protection equipment like gloves and masks and hand sanitizer and lots of items that were that had a surge in demand because of the pandemic. CADE initiated that investigation, and recently, as early as like 2 weeks ago, they dismissed those investigations because they didn't find any anti-competitive conduct specifically. So I think that in conclusion, the idea here is basically that we are dealing with a situation in which we have, let me just, let's stop sharing here. Okay. So we are dealing here with a situation where the ultimate goal of CADE is to make sure that they are keeping up with whatever trends there are, but CADE is being very thoughtful and very mindful of not creating any tools that are specific to this market and making sure that the traditional antitrust tools are being used properly. And that's the main conclusion that we can draw from recent enforcement trends in Brazil. well, thanks to everyone. I think that that's it. If there are any questions, I'm happy to discuss.
Sorry, I was talking with you. I cannot. Yeah, dear Marco, thank you for your presentation. Many issues for sure we need to continue discussing. We have running out of the time. Then I'm gonna introduce Ms. Sandra Ortiz, who is the Director of the Telecommunication Information Technology Department at the Law Faculty of Externado University, and is going to deliver a talk about the National Planning Department initiatives on the antitrust in digital markets. The conference will be presented in Spanish. Thank you.
Muy buenos días a todos. Agradeciendo infinitamente la invitación para hablar un poco de qué está pasando en Colombia sobre los mercados digitales y cómo ha sido esa aproximación que tenemos. Entonces, el acercamiento va a ser un poco desde la perspectiva del regulador frente a los estudios que desde el 2017-2016 ha empezado a desarrollar, y pues ese acercamiento en el diseño de política pública que se hizo por parte del DNP en el año 2020, que estamos esperando de alguna manera las conclusiones, y de ahí creo que más duro. Sí. Y que parte de esos estudios estamos esperando que la comisión de expertos que se conformó para analizar cuáles esas aproximaciones al mercado digitales pues se tengan, y pues tengamos de alguna manera pues los documentos que tiene por ejemplo Brasil en el ámbito de prácticas, o algunos elementos que nos permitan determinar cuál es la visión que tenemos en el ámbito de lo que son los mercados digitales y en el ámbito de la competencia digital. Una gran reflexión que ayer leyendo un poco, preparando esta intervención, pues decía que si no tenemos una política adecuada en materia digital, pues obviamente vamos a generar mayores prácticas. Entonces yo creo que el gran mensaje, y atendiendo pues de alguna manera a las personas que me han precedido la palabra, pues la finalidad es que Colombia, y como lo anunciaba Carlos al principio haciendo la presentación, pues no lleguemos tarde a las discusiones digitales y pues estemos acorde a las discusiones globales que se están dando, y que pues tiene una correlación en todos los aspectos, en temas de consumidor, en temas de protección de datos. Entonces de alguna manera Colombia sí tiene que estar acorde a estas dinámicas. Entonces les comentaba que en el año 2016 es curiosamente el regulador de telecomunicaciones, la Comisión de Regulación de Comunicaciones, que despide o presenta a la opinión pública un documento que se llama la ruta digital, y la ruta digital es lo que empieza a analizar, atendiendo un poco la experiencia que estaba teniendo Europa en el año 2015, 2016, es decir, ellos empiezan a hablar de los mercados digitales, empiezan a generar su estructuración, y que va a dar pie a lo que en el 2020 es ese primer borrador de la Digital Mark y la de la Service Act, que son las dos leyes que pues obviamente se presentaron recientemente en abril y que serán objeto de discusión también por parte del externado el próximo, ya una cuña acá, el 30 de junio, porque de alguna manera sí es conveniente que desde la academia hagamos estas reflexiones y por lo tanto sigamos esa cantera y puntos de reflexión por parte para cuáles son esas aproximaciones que debemos tenernos desde el contexto de la economía digital, y por lo tanto empieza a generarse una serie de documentos graduales del 2016, 2017, 2018 por parte del regulador, unos asociados principalmente a lo que es la economía digital, posteriormente cómo yo puedo intervenir de manera ex-ante en los mercados digitales, generando una metodología de análisis. Posteriormente, ese mismo año, un análisis muy efectivo y relacionado a lo que se entiende con el comercio electrónico, y lo que va a generar una senda que posteriormente se va a materializar en un documento también de política pública en materia de comercio electrónico debido a su trascendencia e importancia. Y lo que se hace por parte del Departamento Nacional de Planeación, tomando como estos antecedentes y generar un documento de consulta pública en el ámbito de dos aspectos. Uno, en el ámbito relacionado con la libre competencia y el otro asociado con los derechos y el régimen asociado a la protección del consumidor en el entorno de comercio electrónico. Finalmente, todo se viene a articular con un COMPES, que es el COMPES 412, que está asociado exclusivamente al comercio electrónico, pero que recoge pues toda esta trayectoria y esta hoja de ruta también diseñada por parte del regulador. ¿Qué hace el regulador? Pues en el año 2016 y 2017 identificar las mejores prácticas y a nivel global que se están dando en el ámbito de los mercados digitales. Colombia, pues desafortunadamente no tenemos una aproximación de lo que se entiende por mercados digitales, pero sí hay unos documentos de carácter de soft law que hacen como estas aproximaciones y vienen a determinar o a identificar cuáles son los agentes de la cadena que hacen parte del mercado digital en el ámbito de clientes, de los facilitadores y pues el elemento fundamental a los cuales han hecho referencia anteriormente, que son los disruptores digitales. Entre ellos están los grandes gestores de plataformas. De ahí pues se empieza a evaluar por parte del mismo regulador cuál es el modelo de, si efectivamente ese modelo de autorregulación que se tiene por parte de los agentes es válido o no válido, y cómo se tiene que dar efectivamente la intervención, si una intervención de carácter preventivo o una intervención de carácter sancionatorio, y empieza a articularse por los diferentes instrumentos asociados a cómo yo vengo a intervenir estas nuevas realidades y muy asociados a la forma de intervención como se hacía en los mercados tradicionales de telecomunicaciones. Recordemos que pues, la intervención siempre se ha hecho en el mercado de telecomunicaciones, es una red de carácter preventivo, es una regulación de ante, donde yo defino un mercado, defino cuáles son los agentes que efectivamente pueden estar distorsionando la competencia y le estoy colocando unas medidas diferenciales. Y si usted analiza, o cuando ya el doctor Ibarra haga la presentación de correspondiente, qué es lo que se quiere con la ley de mercados digitales, es generar unas posiciones diferenciales frente a los agentes que me generan distorsiones en el mercado, principalmente las grandes plataformas, y por lo tanto colocarle como unas medidas o lo que se denomina como esos guardianes y unos sesgos y un monitoreo permanente. Atendiendo a eso, pues también en esa caracterización que se hace pues de todos los elementos y agentes que pertenecen a la economía digital, pues se encuentra también el sector de comercio electrónico y muy asociado con el ámbito de la logística, porque se entiende que yo puedo hacer todas las transacciones en el mundo digital, pero si yo no tengo acceso a los productos, pues obviamente hay un cuello de botella y hay unas restricciones que se están dando desde otro punto para el desarrollo y consolidación de este tipo de actividades. Adicionalmente, que nos viene a plantear desde el año 2017 y que se evidencia también en el documento que sale a consulta por parte del DNP, es decir, que hay ¿qué está pasando con el marco legal que se tiene para poder intervenir y regular los mercados digitales? Entonces, ¿cuál es la gran conclusión? Pues que la autoridad regulatoria en el contexto tradicional de las telecomunicaciones no tiene aceptado o tiene reconocido este tipo de competencias. Y la autoridad de competencia tiene un marco muy general, pero surgen también las preguntas para saber si es necesario que una autoridad totalmente dedicada a mercados digitales como lo tiene el Reino Unido, producto de estas discusiones y estos análisis que se han dado a lo largo de cuando se empieza a generar y empieza a crecer aceleradamente los fenómenos de economía digital. Entonces, es necesario tener una división específica dentro de la misma autoridad regulatoria en materia de economía digital, o la autoridad de competencia tiene también una dependencia específica en materia de economía digital, o crear otro órgano independiente para asumir este tipo de discusiones. De allí, pues que obviamente cuando se hace la consulta del DNP en el 2010, que les comento que son dos documentos, uno que está asociado a consumidores, usuarios, y el otro que está asociado específicamente a las afectaciones a la libre competencia, pues se determine cuáles son los diferentes factores o elementos que se tienen que determinar si las plataformas o no alteran las condiciones de competencia y si se pueden generar prácticas monopolísticas en ese sector. Entonces, cuando ustedes hacen ese diagnóstico que está basado fundamentalmente en las referencias a diferentes aproximaciones de organismos internacionales, principalmente uno de los grandes referentes que se utiliza es el modelo mexicano, que se analizó el contexto de todo lo que está pasando con la economía digital, pues venimos a tener la gran conclusión es que sí es necesario determinar o no determinar qué tipo de prácticas van específicamente y son susceptibles de ser analizadas por parte de la autoridad de competencia y cuáles efectivamente tienen que tener una acción de carácter preventivo atendiendo al carácter innovador que tienen este tipo de mercados. Entonces estamos analizando diferentes elementos que la autoridad regulatoria viene a cuestionar y viene a decir esto se tiene que tener en cuenta para entender que es la economía y el mercado digital. Y lo otro es quién regula y quién da ese carácter de independencia a esa autoridad para que pues obviamente no haya esos fenómenos de captura. Y pues en el contexto colombiano los enfrentamos a tres situaciones. A saber si la Comisión de Regulación le damos un entorno un poco más amplio, que vaya más allá de las barreras de lo que se entiende las telecomunicaciones tradicionales, que siempre está limitada a sus dos grandes leyes o las leyes que se les asignan o competencias que se les asignan por la ley del Plan Nacional de Desarrollo, o empezamos a generar una normativa diferente para regular los mercados digitales, como lo que está haciendo efectivamente Europa, que consideró pues que los instrumentos que tenían no era suficiente y que tenía que tener dos leyes específicas para regular los mercados y los servicios digitales. El otro es cuestionar si efectivamente es necesario crearnos una nueva entidad. Entonces, sí es crear más un aparato burocrático para entender las dinámicas del mercado digital. Y por último, o generar mecanismos de coordinación de más alto nivel, como lo que se quería con una alta consejería de transformación digital, acá hacer una alta consejería en materia de competencia para dar respuesta a las dinámicas propias de los mercados digitales. Lo que se tiene que efectivamente analizar y que nos empieza a plantear el regulador, curiosamente es el regulador el que nos viene a decir cómo yo tengo que hacer unas metodologías de análisis, cómo, que no lo hemos visto a profundidad de la autoridad de competencia, cuáles son esas metodologías efectivamente de análisis que yo tengo. Entonces, si ustedes miran la hoja de una guía metodológica que se tiene en el 2017, que es de abril, ellos ya plantean cómo es el escenario, sí o no, se empieza a generar los escenarios de intervención y cuál debe ser la respuesta que se tiene que dar en ese momento por parte para solventar las problemáticas que se dan, debido a que pues estamos en presencia también de lo que son los usuarios y pues obviamente otros agentes que demandan en esa cadena que se construye. Cuando también se hace referencia al estudio que se hace por parte del DNP en el año 2020, cuando se hace la consulta por los diferentes centros de investigación asociados con la competencia, viene a determinar cuál es el fenómeno también de las integraciones, cómo yo empiezo a analizar las integraciones. Y también es otro documento también que el regulador elabora, que es empezar a identificar cuál es la trascendencia que tienen los mercados y los efectos de red. Es decir, cómo yo dimensiono la red, cómo son los mercados de dos lados y cómo los empiezo a cuantificar y cómo eso empieza a determinarse los mercados y de ahí las afectaciones que también se puedan dar. Y de allí, en esa identificación de mercados también de dos lados, viene a tenerse un factor determinante el valor de los datos. Entonces aquí se hace un cuestionamiento, ¿cuál es el papel que también vienen a tener los datos en los procesos de integración que antes que no se valoraban ni se cuantificaban? Entonces de alguna manera se empiezan a integrar las diferentes aristas y componentes que antes eran totalmente opuestos y ahorita tienen un proceso totalmente de integración para la toma de decisiones frente a los mercados digitales. Entonces, como grandes conclusiones que se hacen y que pues obviamente estamos en esa tarea y pues atendiendo un poco que Brasil atiende unos documentos un poco más consolidados, se espera que pues que Colombia que requiere una política o un documento ya sea de política pública asociado con los entornos o que se entiende por entornos digitales y por economía digital. Debido a que hay diferentes instrumentos que hablan de transformación digital y demás, pero no están asociados en un solo documento. ¿Cuál es la visión que tenemos frente a estas discusiones que se están dando a nivel global? Lo segundo es cuál es, y desde esa visión integral, pues nos va a determinar cuál es el papel que tiene la autoridad de competencia, si el marco normativo que tenemos es suficiente para solventar estos temas. Recordemos y como se los van a presentar posteriormente. Europa lo que hace es que el régimen de competencia sigue siendo totalmente robusto, pero se da un carácter preventivo porque el mismo carácter dinámico que tiene hace necesario que haya otros instrumentos de intervención para evitar pues que se afecten más los derechos de los usuarios o se pueda corregir y pues que estamos sujetos a las variaciones que se dan en transcursos muy cortos de tiempo y que la autoridad de competencia no puede venir a corregir sino de manera expulsa. Lo otro es el monitoreo permanente de los mercados, las actuaciones que se hacen en materia de promoción y seguimiento de las nuevas tecnologías, que es un elemento que se tiene que hacer, pero ese quién lo tiene que hacer. La CRC hace su labor de monitoreo y de ahí de alguna manera que lo que son las plataformas afectan a los mercados tradicionales. El otro es alivianar o identificar cuáles son las cargas regulatorias que se tienen que dar en ambos mercados y pues obviamente para que se den las mismas condiciones de competencia, porque si hay una migración de ciertos servicios de telecomunicaciones a los servicios que se prestan por parte de las plataformas. Y pues la competencia es ¿cuál? Nos vamos con un modelo de regulación de carácter preventivo, acogiendo el modelo que se está dando por Europa y atendiendo, pues que obviamente es un modelo como en el Reglamento General de Datos Personales que ha migrado y ha permeado pues todas las latitudes. Entonces no será que si nosotros acogeremos este modelo o tenemos que fortalecer los instrumentos con los cuales cuenta la autoridad de competencia para resolver cada una de las problemáticas que se presentan, atendiendo pues que la definición de mercados ya no corresponde a la definición tradicional y sino que ese elemento de mercados de dos lados es necesario para identificar los mercados. Y pues obviamente cuando uno se acerca a estas temáticas, los estudios que ha hecho la Universidad Javeriana en el ámbito de lo que son los efectos de red son relevantes para entender cuál es el papel de la autoridad de competencia y pues las aproximaciones de quién puede estar usando o no de su posición. Entonces yo creo que esa es como la gran tarea que tenemos en las grandes discusiones que se empiezan a desarrollar en el marco de los mercados digitales. Y pues Colombia tiene que buscar unos espacios, y creo que la academia es el escenario para hacer los espacios de crítica y análisis sobre qué es la visión regulatoria, cuál es la visión de política pública y si es conveniente o no tener un nuevo instrumento legal para generar una intervención efectiva en este tipo de mercados que ya pues obviamente superan con amplitud lo que son los mercados tradicionales. Entonces, muchas gracias.
Doctor Ortiz, gracias por su presentación. Es por lo menos refrescante saber que la discusión está servida. Hay mucho por trabajar, seguro, de temas, pero pues el objetivo, tanto creo que de estas iniciativas, es contribuir a esta discusión. Sí, muchas gracias. Quisiera, now, Mr. Daniel, please connected. No? Can show one in the line and maybe. Alejandro, are you here?
Sí, aquí estoy.
¿Quieres iniciar?
Sí, sin problema. No hay ningún problema.
Listo.
Bueno, pues mi presentación no es sobre el DMA, sino esta es la presentación de Daniel. Mi presentación es más sobre las tendencias internacionales en Estados Unidos sobre la política de derecho a la competencia. Entonces, pues, primero, pues muchas gracias a la universidad, al CEDEC y a la CSEP y a sus directores por la invitación. Digamos que, ¿me oyen bien?
Sí, perfecto. No te presenté, pero sí.
Bueno, no, adelante.
Déjame te presento. Here we have Mr. Alejandro Ibarra, partner at Ibarra Rimón law firm, who will introduce us to the recent changes that competition policy is experiencing globally about digital markets. Thank you, Alejandro.
Muchas gracias, doctor Uribe. Preparé la presentación en español porque el doctor Felipe me dijo que la preparara en español, entonces pues la voy a realizar en español. Digamos que todo lo que hemos visto hasta este momento, que ha sido muy específico sobre las distintas maneras de regular, lo que ha retratado es la dificultad que tienen los conceptos de derecho a la competencia clásicos de regular esta nueva situación económica que no solo se está presentando en el contexto digital, sino de manera general en la economía. Digamos que estamos en un contexto de concentración de la riqueza y en un contexto de dificultad de persecución de las acciones unilaterales, y que eso ha llevado a la necesidad de regulaciones ex ante, en este caso, como lo estamos discutiendo, pues en el contexto de la economía digital. Digamos que esto nos enmarca en una discusión más grande, y es cuál es el propósito y cuáles son los fines del derecho de la competencia, y que de manera general nos van a llevar a entender que dependiendo de lo que definamos por cuál es el propósito de los fines de la competencia, la intervención del Estado se justificará de una u otra manera a otra, o en un mayor nivel o en un menor nivel. De manera general y en el contexto internacional, hemos podido ver que Estados Unidos ha perdido su influencia o su posición de líder frente a otras jurisdicciones como la Unión Europea o frente a otras jurisdicciones que han acogido la posición de hacerle enforcement a unos fines que son extra eficiencia o que no involucran solamente la eficiencia. Y esto nos ha llevado a que dentro del mismo Estados Unidos se genere una crisis sobre qué debe perseguir y qué debe hacer el derecho de la competencia. En ese sentido, vale la pena tener en cuenta que jurisdicciones como Sudáfrica, esto no solamente es el interior de Estados Unidos, sino jurisdicciones como Sudáfrica, han incluido entre sus jurisdicciones fines como la justicia y la protección de poblaciones históricamente discriminadas para evaluar para evaluar las distintas prohibiciones del derecho a la competencia. En ese sentido, enfocándonos en lo que ha pasado en Estados Unidos, hay que mirar un poco la historia, y es que antes de los 70s, básicamente el enforcement o la persecución o la investigación, la fiscalización de las normas de competencia era una, y después de los 70s hasta el día de hoy era otra, antes de esta administración. La forma original de la ley Sherman originalmente propende por unas finalidades mucho más amplias que no son solamente el bienestar del consumidor. Propende por la protección de las pequeñas empresas, la estabilidad laboral, proteger el proceso democrático y también el bienestar del consumidor. Eso llevó a que en las primeras etapas de la aplicación del derecho antitrust en Estados Unidos, como bien decía Krisztian, que son los precedentes que se están utilizando hoy en día para fortalecer las nuevas posiciones, buscaran una estructuración de mercado completamente desconcentrada, en la que no se permitiera la acumulación de grandes participaciones de mercado, todo esto buscando evitar las circunstancias que llevaron a Alemania a las dos guerras. En esa medida, pues, el enforcement del antitrust en estos momentos estaba basado en carteles y estaba basado en persecución de conductas unilaterales. Después de los 70 y con la influencia de la Escuela de Chicago, y aquí es donde viene el punto de quiebre, de una u otra manera, lo que empieza a pasar es un cambio. Doctrinantes como Robert Bork empiezan a decir hay que ignorar los fines extra eficiencia y hay que quedarnos solamente con el bienestar del consumidor, y muy hábilmente la administración Reagan empieza a nombrar jueces y posiciones importantes para mover ese threshold de la regulación y buscar que esos fines extra eficiencia dejen de ser aplicados en la jurisdicción norteamericana. Lo que logran de manera muy eficiente, y con esto lo que terminan haciendo es que el enfoque de la regulación se basa únicamente en eficiencia. El principal enfoque es los carteles empresariales, y la persecución de conductas monopólicas es mucho más ligera. La preocupación es el monopolio puede traer eficiencias que yo no quiero que yo no quiero ahuyentar. Esto lleva a que desde los años 2000 una escuela muy crítica dentro de Estados Unidos empiece a decir no estamos logrando los objetivos. ¿Cuál es el objetivo del derecho a la competencia? Casi que esta escuela empieza a ver el derecho a la competencia como una especie de elemento de redistribución de la riqueza, y a la fecha, hoy en día tenemos 3 escuelas grandes que podemos hablar dentro de Estados Unidos, que según William Kovacic podrían denominarse como tradicionalistas, que son los que dicen que el enforcement desde los 70 hasta la fecha está perfecto. Los expansionistas, que básicamente quieren un enforcement más agresivo, quieren buscar que haya más fiscalización, pero aún así respetan los fines de eficiencia. Y finalmente, los transformistas o los neograndesianos, que básicamente lo que están buscando es que se vuelva a hacer una fiscalización de esos fines que son extra eficiencia. Y con esto estamos hablando fines de la protección de las de pequeñas empresas, la estabilidad laboral, los nuevos emprendimientos, el proceso democrático, y eso nos saca de la misma lógica que hemos hablado o que entendemos y hemos estudiado en la competencia en los años recientes. Y aquí se vuelve muy importante la pregunta que hacía el doctor Uribe en materia de cómo medimos, a qué iríamos, porque parece ser que ellos no plantean un esquema muy claro de cómo debe medirse, y de hecho hay una especie de escepticismo a la técnica económica y plantean es un acercamiento más holístico. Entonces, dependiendo de cómo se aproximen estas finalidades, pues tendremos un resultado de intervención u otro. Ya en Estados Unidos vemos claramente cómo esta corriente que hace unos años se hubiera pensado que no tenía ningún chance de volver a subir al poder, pues ha logrado un gran trayecto. Lo primero que hace Biden al entrar, aparte de nombrar a Lina Khan, a Tim Wu y a Jonathan Cantor en las distintas oficinas, es sacar una orden ejecutiva en la que básicamente denigra el antitrust o el enforcement que se ha hecho durante los últimos 40 años, y en el que dice, básicamente, acepta que Estados Unidos de una u otra manera se ha equivocado y que lo que se necesita es empezar a pelear contra las grandes empresas y buscar desconcentrar la economía, especialmente en el sector tecnológico, con el fin de buscar la estabilidad laboral, la protección de las pequeñas empresas y de los emprendimientos. Por otro lado, esto se ve reflejado en que, como nos lo contaba Krisztian, básicamente el año pasado la FTC retira las guías de concentración vertical, y aunque no se han publicado los nuevos borradores en los requerimientos de comentarios, sí se puede entrever que las nuevas guías van a tener un enfoque completamente diferente, una forma de evaluar las eficiencias que es completamente distinta, y a esto me refiero a que, por ejemplo, los cortes en mano de obra, que en otro momento podrían entenderse como disminución de costos y sumarían como eficiencias a favor de las empresas, hoy en día o en un futuro podrían llegar a entenderse como en contra de las empresas, en la medida en que lo que se busca es garantizar la estabilidad laboral. Por el otro lado, tenemos que se busca también evaluar quién es el que está comprando la empresa, si es un fondo de inversión y lo único que le interesa es romper la empresa o preservar la empresa, dependiendo de cuáles sean las tendencias de ese fondo de inversión, y establecer unas presunciones en ciertas integraciones en la medida en que tenga que ser el agente integrado que pruebe que la concentración es beneficiosa para la economía y no al revés. Finalmente, estas personas son las mismas que están llevando los litigios que curiosamente empezaron en la administración Trump, como son los de Google, Facebook y Apple, pero pues le han dado su propio enfoque, como se puede ver en el amendment complaint que presentó la FTC el año pasado bajo el nombramiento de Lina Khan. Por otro lado, vemos ciertos logros de la presentación de leyes. Tenemos en especial the Competition Antitrust Law Enforcement Act, the Merger Filing Fee Modernization, the Access Act, and the American Choice Innovation Act, que como bien lo contó Krisztian, básicamente se están preocupando por la discriminación y por las ventajas que pueden tener las plataformas digitales en sus propias sobre sus propios servicios, discriminando los servicios de terceros. Se busca fortalecer y ampliar el presupuesto de las agencias y al mismo tiempo se busca garantizar que las empresas den acceso y no limiten a terceros la posibilidad de entrar a estas facilidades. Ahora, es importante discernir que hay ciertos proyectos de ley que están enfocados directamente en el mercado digital, y hay otros proyectos de ley que están enfocados de manera general en la economía, y lo que buscan es esta nueva persecución de estos fines, no solamente en la economía digital, sino en toda la economía norteamericana. Aquí la pregunta que se hace dentro de Estados Unidos es, ¿vale estas reformas y estas nuevas tendencias se van a mantener o no se van a mantener? Y lo importante aquí habría que decir es que el tiempo está en contra de los neograndesianos y pues de sus reformas, en la medida en que el precedente, como bien lo decía el doctor Uribe en algún momento, hasta ahora que se ha desarrollado en Estados Unidos, es completamente liberal y está en contra de las posturas que ellos han desarrollado, con excepción de la materia de integraciones, porque el último pronunciamiento de la Corte Suprema en materia de integraciones fue en los años 70, y por eso es que están utilizando estos pronunciamientos de los años 70 para poder basar sus guías en materias de integraciones. Sin embargo, si el Congreso no entra a regular la materia, lo más probable es que la conformación de las cortes de hoy en día no permitan volver a mover la aguja, porque en ningún momento se ha hecho lo que se hizo bajo la administración Reagan, que fue nombrar jueces en las cortes importantes, y de hecho el último nombramiento de la Corte Suprema de Estados Unidos, pues es una discípula del juez Breyer, quien es claramente un liberal y quien ha sido parte del defensor de la Escuela de Chicago. En ese sentido, pues es difícil pensar que en Estados Unidos estos cambios puedan mantenerse sin la acción del Congreso, y la pregunta es si luego de las elecciones se van a poder mantener. Lo mismo frente a los litigios, en la medida en que, pues, si bien hoy en día Lina Khan y Canter están llevando los litigios, probablemente cuando estos litigios finalicen ellos no van a estar dentro del cargo. Entonces, el espectro de tiempo está en contra de ellos para poder realmente lograr los cambios que están buscando. Finalmente, es muy importante ver que estos fines que están persiguiendo los neograndesianos y que van a aplicar tanto a las economías digitales como a todo el sector y a todo el control de integraciones, tienen conflictos entre sí, porque pues una cosa es buscar la eficiencia y otra cosa es buscar la estabilidad laboral. Y no es muy clara cuáles son las métricas que se van a utilizar para realmente darle certeza al empresariado y poder llegar a generar mensajes claros desde el punto de vista de política pública. Esto en contraste con lo que ha pasado en la Unión Europea, en el Reino Unido, que pues básicamente sus políticas y sus leyes han sido mucho más flexibles, han sido mucho más, digamos, en la Unión Europea, los fines extra eficiencia, si bien no están consignados como están en el Sherman Act, están embebidos de una u otra manera en el Tratado de Fundación, y no son los mismos, básicamente hace referencia a la sostenibilidad de la justicia, y los han ido aplicando cuando los han considerado necesarios. El año pasado, Margaret Vestager estaba hablando del Green Deal, cómo la política de competencia podía ayudar en efectos ambientales para propender por una política. Si bien ese no era el fin fundamental del derecho a la competencia, no desconoce la utilidad de la política de competencia para poder llegar a generar unos objetivos extra eficiencia. Lo mismo ha pasado con el CMA y con la regulación de competencia del UK, en la medida en que han empezado a generar mecanismos distintos a la definición de mercado o a la técnica pura económica para llegar a medir el poder de mercado y para empezar a controlar a las grandes empresas. Y de nuevo, vuelvo al ejemplo de Sudáfrica, porque es uno de los ejemplos en este momento más estudiados, cómo a través del derecho de la competencia y la inclusión de la protección de poblaciones históricamente discriminadas a través del derecho a la competencia, lo que se ha buscado es contrarrestar toda esa discriminación hacia las poblaciones raciales y darle un tratamiento más favorable en materia de competencia a las empresas que son propiedad de estas comunidades, de tal manera que se busca nivelar la cancha de juego de una u otra manera. Ahora, en Colombia, la pregunta es si estas discusiones son pertinentes, y yo creo que claramente lo son, y cuando miramos cómo Europa o cómo Estados Unidos está pretendiendo regular la materia, lo cierto es que vemos que la actuación de Estados Unidos ha sido tardía, prácticamente no vemos como una actuación futura en la que llegue rápidamente, salvo por lo que están haciendo en las guías de concentraciones y en las investigaciones. Y nosotros en Colombia tenemos que preguntarnos si queremos seguir el mismo camino de Europa y cuáles son los fines que vamos a perseguir, que de una u otra manera están en nuestra norma, pero que esas actuaciones realmente se ajusten a nuestras realidades de mercado. Tenemos que tener en cuenta que somos una economía mucho más pequeña y que básicamente prohibir o generar prohibiciones muy grandes puede llevar a realmente a sacrificar eficiencias y calidad de los productos que la población podría llegar a necesitar. Con eso sería todo. No sé si hay preguntas o algo al respecto.
Gracias, Alejandro. Creo que ya nos está esperando Daniel. Last but not least, here we have Mr. Daniel Sokol, professor of GOULD School of Law in the US, who is going to talk about one of the most challenging issues in competition right now, ante regulation in digital market. Please,
Thank you. I very much appreciate the opportunity to participate in this launch. I'm so sorry I could not be there live. It's really a tremendous time to be thinking about digital issues. We're at a point of real digital transformation of businesses. We saw, I think, a first wave of businesses that were leaders, and this is largely of companies, for example, that are in Krisztian's association. But in fact, digital transformation is a way of life now for every company. I cannot think of a traditional industrial company or healthcare company or the company that even just produces end consumer products, you know, whether it's Nike or FEMSA, that isn't undertaking its own digital transformation in some or all of its business, and actually thinking very much about platforms, you know, and marketplaces. We focus on B2C because that's where the transformation happened early, but in fact, B2B is just as important, but is oftentimes forgotten within the competition community. The digital transformation is possible largely because we have a computational revolution. So everyone that had been not cool when we were growing up, you know, nerds, all of a sudden are the coolest people that we know, right? It's no coincidence that Big Bang Theory for many years in the United States was the most watched show because we said, oh my God, I also want to work at Caltech. So why does that matter to competition issues? With digital transformation comes industrial disruption. It's not the first time we've seen industrial disruption. We were reminded this past week with the Queen's Jubilee that, you know, the longest reigning queen was Queen Victoria. And if we think about Victorian England, this is when we had significant industrial revolution, change in business models, in the means of production. All of a sudden, the factory system was put into place. And not surprisingly, in part, this was driven by technology. And this is when basically science fiction really took hold as a sort of area of writing, because people were scared about technological change. We're in a new era of growing income inequality in the world. If at the macro level, some 15 to 20 years ago, we focused on the breakdown of Washington consensus, we're now seeing it at the micro level as well, where we hadn't before. And partly, we are concerned in a competition context about regulatory change. Why? Because of failures in other parts of government, lack of equity with regard to taxation, lack of investment, you know, in lesser served communities, and people feel angry when they see this kind of inequality. And we're seeing this kind of broader techlash. And this techlash is real. It's happening everywhere in the world. And it's, by the way, also happening at a time where overall center political parties are collapsing around the world. And we're seeing push to extremism. We have populism of the right. We have populism of the left. What are we to do as a competition community? Well, there's been a push to regulation. And regulation in and of itself is not problematic. And I'll give you the happy story of where I think it's working. And then I'll give you some general principles. So it turns out, if you want to see really innovative reform relative to other jurisdictions, don't look at the United States. God forbid you look at the European Union. Actually, look at the UK. So in the UK, they identified one thing that's very important. It's very difficult to regulate it's very difficult for companies to invest and to innovate when there's regulatory uncertainty. So the Financial Conduct Authority for issues of fintech has created a regulatory sandbox. So companies, whether they are fintech companies or even larger companies going through digital transformation, traditional banks, but believe it or not, even the UK Postal Service, they go into the regulatory sandbox and they propose all kinds of business model changes and additional services, and they get assurance that this is going to work out, and then they're willing to invest. It's a beautiful system. You know what else is a beautiful system? In the UK, there's been a push to get the Financial Conduct Authority, the telecom regulator, the competition authority, and the privacy authority to really talk on a regular basis. And I think this is hugely important because each of these different regulators has a different set of assumptions, has a different set of goals. Sometimes they are synergistic, sometimes they diverge, but actually having them talking on a regular basis is really helpful. We don't have that in the United States. You certainly don't have that at the European Union level. This in many ways is, I think, the better way to go. And I mentioned that to you largely because I think when we work through how do we think about regulation, in much of competition, if we have effective enforcement, we don't need as much regulation because we're able to identify anti-competitive conduct. We're able to address it, whether it is collusion or exclusion, or sometimes a mix of collusion or exclusion. And agencies around the world do that, and they do it effectively. They also do it effectively in digital markets. But when you have regulations, because somehow the existing toolkit may be insufficient. So do we have guiding principles? Competition authorities move from enforcers to being enforcers and sometimes regulators as well. I think we do have principles that would be very helpful. And I draw these principles both from the successes that I gave you, I think the best success, which is the UK, and a lot of the failures, which is a lot of the rest of the world. And I'll work you through 6 principles, if I may, in my limited time. The first is define the scope of regulation. If you're going to regulate, you really need to explain what the regulation is intended to do and who it is intended to cover. The DMA is not really clear about that. The DMA is in fact awful in another way. I think we're going to have a constitutional law crisis as to who is in charge of the DMA. If you read the text of the DMA, you'd think it's clear. It's at the commission level. If you went to the most recent ICN meeting, all of a sudden every national authority tells you actually they're in charge. This is not tenable long term, and this is going to have to be solved. But what it means is that companies are chilled in their investment decision making. Companies want to make business and make profit, and so long as it's not anti-competitive, we should encourage them to do so. We benefit across multiple ways of doing that. Number one, it creates more wealth. Number two, that wealth can be reinvested. And when you don't have that clarity, you have neither. Second major principle is you have to make the purpose of regulation clear, and it has to be linked to some economic objective, you know, that is a truly objective in the following sense. It's not, it's good for me, but not for you. So why are we regulating? If you cannot articulate a economically defensible reason of why you regulate, I don't want this regulation. I don't think anybody should want this regulation because it means the naked ambition of politicians and of the political processes driving things forward. That kind of monopoly power by government really scares me. By the way, monopoly power by private firms also scares me, but the kind of abuse that one can have in the political process in some ways is worse. And if you don't have some kind of objective outcome that can be applied fairly, it creates a long-term political problem in that people feel that competition regulation is being weaponized in a very overtly political process that is unfair. By actually making the purpose of regulation fair, we address this. You know, and by actually saying this is the objective, here's the economic basis for it, you save yourself that kind of problem. You basically bind yourself to a workable system. And when I say that on the substantive side, the next point should also make sense. I think procedural fairness matters. So another problem in the DMA, for example, we move it directly to remedies. Wait a second, what about due process? So I'm concerned, particularly in Europe, where we see the Intel case continuing to be appealed, where, you know, exculpatory evidence against Intel was withheld. I love it when we play by the rules and we have procedural safeguards. Number one, because I think rule of law is really important in every jurisdiction. Number two, when we're good on process, we cannot question in the same way the substantive outcomes. And I think that adds legitimacy to competition authorities. I think it adds legitimacy to the competition system. We should have procedural fairness. Transparency and due process, both are important. We've seen a weakening of that across a number of systems, including, unfortunately, in the United States under the Federal Trade Commission, where we have less engagement than we did before. That's a problem. Where there have even been meetings that they say we're going to have discussion about what we're going to rule on, but they rule first and have discussion afterwards. You know, this is not some communist show trial in Hungary circa 1956. You know, that's not how we should operate. If we believe that diverse viewpoints and the idea of sharing information leads to better outcomes, this is exactly the wrong way of doing it. Let's try to come up with a system that takes procedural fairness seriously. But the other thing, and the reason I push against Europe, is because regulation should not be the end of competitive effects analysis. My full-time job is as a professor. And if someone only gives me the answer, but doesn't show the work, I'm not sure that they really understood the problem. And I say this because I literally just had to grade a lot of exams this past month. So this is very much on my mind. Show the work. The beautiful thing about competitive effects analysis, it also creates legitimacy because you've shown through evidence wrongdoing. And you could stand behind the cases that you bring. And you know that while companies might be upset about an individual case, they don't question the system. And I think that's really important to the legitimacy of the authority and in the entire competition ecosystem. The other thing that I would suggest in regulation, avoid what I think are obvious mistakes. I don't want to see blanket bans or blanket rules. I don't want to see per se legality, but I also don't want to see per se illegality, because neither of those, except perhaps in hardcore cartel cases, really reflect economic realities. And when we have blanket rules that prevent, this destroys economic value. There's a lot of empirical work across fields. For example, blanket rules that prohibited vertical integration under banking regulation in the United States It's very clear from work in the American Economics Review and the Journal of Finance, it hurt, innovation in banking, it hurt competition in banking. We saw how this hurt in airlines. We didn't have cheaper fares until we got rid of the system we had. When we had the Interstate Commerce Commission, their blanket ban on vertical integration turns out was also a disaster. Blanket bans don't work. And in fact, we can say the same for the move in all kinds of vertical restraints from per se illegality to rule of reason. Now, I mentioned to rule of reason, but I want to note something. If you look at the early Chicago school writings, Borg, Posner, Easterbrook, they all pushed for per se legality of vertical restraints. That was wrong too. That was wrong because actually at the time we didn't have as much work. Now we have work that under certain settings, vertical restraints may be anti-competitive. We also have a lot of work that says vertical restraints are not anti-competitive. And so it puts us in a difficult political position. We actually have to show our work and do that work. And it means investigations. And sometimes we investigate and we find no wrongdoing. That takes courage. That takes courage because it means we've investigated, we've done our job. Politicians, you need to understand there isn't enough here. And that's not always easy to do. And I always think that that's one of the most courageous things that an agency can do. Investigate and then say, we don't have enough information here to move forward. But I think that that really matters. And this gets me to my last point, and I'll end here, really. Regulation should be guided by what we know empirically. So we have increasing empirical work in digital markets. Most of it is not in economics. It's in information systems. It is in marketing. It is in strategy. It is in finance, focusing on markets that matter and markets that matter also for Latin America, fintech, e-commerce. And by e-commerce, I don't merely mean end consumer, I mean logistics, supply chain, B2B. And what we see from these literatures is, number one, overall pro-competitive results, which suggests that some of the important theory papers on digital platforms in the 1980s, good papers, good theory papers, need to be revisited. Because if theory does not comport with reality, either the reality that we are observing is not true, it's not the case, or in the alternative, we need to rethink theory. And I think economics and antitrust analysis is always trying to think about how to fit all kinds of empirical insights into our decision rules. And on that, I will stop and hand it back over to Felipe with one final caveat. We have very little academic empirical work using Latin American data. And if one thing that this center could do is to take the kind of investigations, whether via survey or data scraping off of the web, or even with company-specific data to help really explain that Latin American specific empirical reality, that would be of tremendous value, not merely to to the authorities in Colombia, but really across Latin America. Thank you.
Thank you, Daniel. Okay, I understand we have a very hard work in front of us, but for sure it's going to be rewarding if we can accomplish at least part of what you are proposing. Then, no sé si alguien del auditorio quiere hacer preguntas en español. Bien. ¿Acá? ¿Así? Sí, el micrófono está arriba.
Okay. I will have a quick one for Krisztian. You mentioned Exposto studies to review if there are mergers that are not being caught. Is that a real issue? Is there any international evidence of mergers going under the radar and not being caught?
Thank you. I guess I don't see you, but I guess based on the voice, that was Carlos, right?
Yes, it is. Yes, it
Thank
is.
you. Thank you for that question, Carlos. Yeah, I mean, it's a very important, like topic that I think when it comes to kind of like what evidence, what empirical evidence we have, like it really is part of the reason that I think we really have to step back. And what I also talked about before, you have to think whether there is anything that is being missed that perhaps, some computational authorities do bring up sometimes, but you actually do not really see any empirical evidence in that regard. When it comes to ex post assessments, you see that over the last couple of years, a number of computation agencies, I think I briefly mentioned that as part of my initial remarks as well, really have been focusing on doing more, like ex post analysis of previous mergers, in particular, focusing on digital markets. I think I mentioned the Lee report from the United Kingdom. I think that looked very closely at 5 digital mergers and tried to see, over a period of a number of years when those took place, whether perhaps, they should or could have been challenged. But then also, I think I mentioned the FTC example of looking at 10 years of technology mergers, a similar exercise done by CAGI in Brazil, and I think the Israeli Computational Authority. When I looked at any of these reports, it seemed that there was no evidence that there was any kind of like, merger or any kind of like major systemic concern that perhaps there were mergers that were not caught. A couple of things that I would also add on that, in addition to your question, Carlos, there were a number of changes, legislative changes from a number of, like jurisdictions over the last few years that also, once there was more discussion about these so-called killer acquisitions that we've heard a lot about, we're trying to see, again, is there an issue? Is there a gap in merger enforcement? Are there mergers that are not being caught by agencies? And I think it was the 9th Amendment to the German competition law back in 2017, when, for example, Germany and Austria introduced new transaction value-based thresholds exactly for this particular reason, to actually try to like catch additional mergers that perhaps were not caught before, and that, like in the agency's mind and the legislation's mind, perhaps, could be problematic from a competition perspective. I looked at the data, for example, for the last month or so, for the last 4 or 5 years, and apparently none of the mergers that were caught under the new transaction value-based thresholds actually led to, like a merger challenger. So I think they were all cleared in the first phase. So it seems that, there's no evidence that there's kind of like any major issue or a systemic problem that was not addressed before. And in addition to Germany and Austria, other countries, France, Japan, I think made similar changes to be able to kind of like catch more of those mergers that really mostly was brought up, kind of like by this session or by this discussion on killer acquisitions that really was focused more on pharmaceuticals and pharmaceutical transactions and mergers. And there was basically one paper, I think it was in 2018 by Cunningham et al., that really looked very closely if in the pharmaceutical sector, are there killer acquisitions that perhaps were not reviewed and then led, like to any competition problems. And I think it came up with an approximation of about 5 or 6% of perhaps some of those pharmaceutical transactions could have been problematic over time. But then I just want to add one last point, like to this as well, that when it comes to the competition agency's toolkit and toolbox on how to address mergers, in a number of jurisdictions, there's also the possibility for the agencies to review non-notifiable and consummated mergers. And as far as I'm aware, I think, in Colombia, SIC doesn't have that kind of like authority, but in other jurisdictions, for example, in the United States, mergers simply do not actually officially get cleared. What that means is, like if there's no challenge by the agencies, and then there's a consummation of the merger, as you may know, like even potentially years later, the agencies actually can, and they actually do go back and can challenge consummated mergers as well. So in that regard, that issue, if there was a previous competition issue that wasn't addressed in the first place, can, like with its difficulties, obviously, for remedies, but could be addressed later. And in other jurisdictions, there are similar authorities too. I think, from Brazil, CAGI actually has a time limit. I think they can go back for a year after consummation of a merger, but they can also review consummated mergers. So I think with all of these kind of like tools and the kind of like research and the evidence that we have, I really don't see that there would be kind of like any international consensus of missing particular harmful transactions. Thank you, Carlos.
Sorry, we have another question.
Okay, this goes to any panelist that wants to answer, and is, do you think like digital market agents that may be affected by the regulation should have like an active role in these discussions?
Danny, do you want to answer that? Krisztian?
Yeah, could you please repeat it? I caught the first part, but then I was just kind of like trying to take notes, what the question was. The second part, I didn't really get very clearly.
Is if you think that digital market agents that may be like affected by the regulation should have like an active role in this kind of discussion.
Oh yeah, I understand now. Thank you. Yeah, thank you for the question. I'm happy to kind of like jump in and Alejandro or others, feel free to comment. But yeah, I think it's extremely important that these discussions, about potential regulations or so do take place with the participation and the engagement of stakeholders. And I think that's what you see, kind of like it's kind of like another concern that potentially with a number of legislative proposals and regulatory proposals in jurisdictions, perhaps they're also rushed through very quickly. And then I think you see kind of like potentially like a lack of that level of engagement, like that we really have been seeing in a number of jurisdictions. As these reforms are being considered, I think it couldn't be more important to kind of like get the views of who it would actually apply to as well. And then who would be kind of like covered companies and get a sense of kind of like how it would really, from a broader perspective, affect, as I mentioned before, kind of like the broader market and the innovation, the innovative ecosystem in the market. So my short response is yes, I think it's extremely important that this engagement, like takes place, and there's kind of like consultation process as well about any of these proposals. I don't know if Alejandro, Marcus, or Denny or others would want to weigh in as well.
Yo estoy de acuerdo con lo que dice Krisztian, además porque los agentes son los que tienen el conocimiento especializado de su negocio, de su mercado, de sus eficiencias, de cómo funcionan. Y va a ser muy difícil para el regulador establecer una regulación y sacar las eficiencias al máximo desde afuera. Realmente es la simbiosis de regulador y agente el que puede traer lo mejor de la regulación.
Yeah, I completely agree with Krisztian and Alejandro. I think that regulation needs to take into account the practical aspects of the market to which they will apply, and the regulator often does not have a full view of that. So I think that not only companies, but also the competition law community, lawyers that represent these companies, as well as academia, and I think that's why this initiative here is so important. All of these stakeholders need to have an active role in the creation of new regulation to the extent that that is actually necessary.
Another question? Okay. Yeah, please.
Yo tengo una pregunta para Alejandro, y es, nos comentaba cómo en las últimas, digamos, políticas públicas en Estados Unidos pareciera que el derecho de la competencia estaría encaminado a desmontar, digamos, las grandes empresas y propender por, de alguna manera, si se permite el término, democratizar esa participación de mercado, ¿sí? Quisiera saber en Estados Unidos cómo está influyendo la pelea no solo de las grandes empresas, digamos, locales de allá, sino con las empresas de Oriente. Eso de alguna manera, en mi opinión, también ha cambiado la forma de ver el derecho de la competencia. Entonces, esa pelea, digamos, entre Oriente y Occidente, ¿cómo se ha visto afectada o beneficiada para Oriente, desde mi opinión, con esas políticas que Alejandro mencionó en su intervención?
Bueno, no estoy seguro si entendí correctamente la pregunta, pero voy a responder cual sí que algo pendiente me dice. Digamos, lo primero, pues el término, digamos, democratizar, como lo entendemos nosotros en Colombia, creo que no es lo que aplica correctamente, sino lo que buscan de una u otra manera es, al hacer o fragmentar las empresas, es pelear contra el poder de mercado sin necesidad de que entre el Estado a tener alguna propiedad o algún asunto, si estamos entendiendo democratizar dentro del contexto colombiano. La preocupación es básicamente que hayan agentes muy grandes que no solamente concentren la riqueza, sino que puedan hacerle un match al poder del Estado de una u otra manera o influenciar y cooptar los reguladores. Entonces es necesario desconcentrar las economías de tal manera que se permita la entrada de pequeños participantes. De cara a lo que es Oriente, y no estoy seguro si te refieres a empresas chinas, digamos que pues hay nuevos acercamientos y nuevas teorías que dicen que básicamente uno debería entender a las empresas chinas como un solo agente integrado en la medida en que de alguna u otra manera están controladas por el Estado. Sin embargo, pues no son teorías que han sido acogidas por los reguladores, que no son teorías netamente académicas, y a la fecha creería yo que cualquier prohibición o cualquier trato diferenciado sería por fuera del antitrust, porque realmente hoy en día cualquier integración o investigación va a pasar por exactamente los mismos filtros, al menos dentro de Estados Unidos. No sé si con eso respondo a tu pregunta.
Gracias, sí. Gracias, Alejandro. Miguel, muchas gracias. Y la última pregunta, Carlos Guerra.
Yeah, but I realize that we really run out of time, and I'm sure they have to run to other meetings. So I'm not sure if we have enough time for another one. Actually, my last question will be directed to Danny. So I'm not sure if he's still there. Probably have to jump in.
Danny, are you here?
Yeah, I think we all abused of their time already. So
Okay, thank
I
you
resign
very
my
much.
question.
Okay, thank you, Carlos. Okay, thank you to all our speakers. It has been a very insightful morning to think about the many challenges that competition law has in front, especially to incentive innovation in digital markets, but at the same time to protect rivalry and challenge for closer practice that avoid competition and restrain consumer welfare. The present Research Institute initiative in digital competition and e-commerce is willing to have more events like the one we have had today. Thanks again, everybody. Thank you for being here.
Thank you.
Thank you very much. Bye-bye.
Nice to see you.
Great seeing you all.
Thank you. Bye-bye.